Welcome to today's webinar brought to you by OraSure Technologies Incorporated. OraSure Technologies is a global leader in oral fluid substance abuse testing products. Their unique assays provide accurate and easy-to-administer testing methods to help determine the presence or absence of drugs or alcohol in a person's system. Oral fluid-based testing products provide a simplified collection process, faster results, cost savings with minimal risk of tampering, and dramatically reduced risk of adulteration. The Intercept Oral Fluid Test is an FDA-cleared laboratory-based oral fluid drug testing system that enables accurate testing for drugs of abuse, including marijuana, cocaine, PCP, amphetamines, and opiates. With a fast and easy-to-administer collection process, Intercept is ideal for workplace, criminal justice, drug treatment centers, and clinical setting screening programs, among others. Today's presentation is entitled Legal Impairment in the Workplace, What Employers Can Do About It, and will be presented by Bill Current and Robin Cagle. Bill Current is the president and founder of WFC & Associates, a national consulting firm that specializes in drug testing policy development and providing accurate and up-to-date state drug testing law information. He is the editor of the online Ultimate Guide to State Drug Testing Laws at statedrugtestinglaws.com and the publisher of the e-newsletter State Drug Testing Laws Monthly and the weekly e-news service Drug Testing in the News. He is the author or co-author of 10 books on substance abuse issues, including Why Drug Testing. He also administers the annual Drug Testing Industry Survey, now in its 15th year. Robin Cagle joined Trident National Corporation in 1999. She currently serves as vice president. She has been in the drug testing field for almost 15 years and is experienced in all aspects of the business, including drug and alcohol testing, random management, employee education, and supervisor training. Robin oversees daily operations along with sales and marketing. Today's presentation is approved for 1 credit hour of continuing education for CSAPAs by SAPAC. Further information will be provided at the end of our presentation. It will now be our pleasure to hear from Bill Current and Robin Cagle.
Well, Jessica, thank you very much. I'm going to go first in our presentation today, and then I'll be handing it off to Robin a little bit later. I'd like to thank all of you for coming on the line today. I'd like to start out by thanking OraSure Technologies for this wonderful monthly webinar series that they host, providing educational information to drug testing providers and drug testing buyers, and also to Trident as well for co-hosting today's webinar. We're going to talk about legalized impairment. And I know that kind of sounds like an oxymoron, but that seems to kind of be where we're headed. We're going to talk about what's gotten us to this position, where we're sort of heading from here, and then what employers can do to protect themselves and their companies and their non-drug using workers with a good drug testing policy, and how oral fluid drug testing can help detect marijuana and put a real solid touch on your drug-free workplace program. Robin's going to talk a little bit about that as well as in her portion, as well as some of the experiences that she's had with companies that have faced this challenge and made the switch from some other type of testing program to oral fluid testing. I'll leave the rest of her presentation to her. Let me start out by just setting the table and presenting a few statistics. We won't pause on this for very long, but every year the government puts out a report called the National Survey on Drug Use and Health, where they report on the latest trends in drug abuse in our country. And the latest study that we have from 2011 showed an estimated 22.5 million Americans over the age of 12 who self-admitted to being current drug users. And the government defines a current drug user as someone who admits to using drug with at least one time in the last 30 days. And that's up 8.7% of the population in 2011 versus 8% in 2007. That 0.7 may not seem like a lot, but when you consider the millions of people that are in our country, that's a pretty significant movement. I mean, if we were talking politics, the pundits would be calling that a statistically significant increase. And a lot of that drug use increase is because of the surge in marijuana use. And there's some statistics here that show the increase over the last 5-6 years. At the heart of this is also an increase in drug use among young adults. and marijuana use among young adults, 18 to 25 years of age. I point that out only because, one, overall the problems increased, and two, the segment of society that many employers tend to hire from that 18 to 25 age range, that's where a lot of the statistical increase is coming from that age group, and also from youth, 12 to 18, where there's also been a fairly significant increase in marijuana use among that group as well. I wrote a book several years ago called Today's Teen Drug User, Tomorrow's Job Applicant, to sort of underscore the importance of employers paying attention to these trends, because the kids who are using drugs in high school now, who have these lowered barriers about drug abuse in general and marijuana use in particular, are the people who are knocking on our doors looking for jobs today and in the near future as well. So these statistics are very, very important. Now, there's something going on in our country right now that on the surface one might not make the connection with the marijuana movement, but it really is part of it, and it's fake marijuana, synthetic cannabinoids. You might know it as K2 or Spice or one of the other names, brand names that are out there, but it's not real marijuana, but users experience some of the effects of real marijuana. Spice is a slang term, really, for synthetic cannabinoids, and these chemicals are applied to, they may be sprayed on herbs or some other type of herb-like substance, something that looks organic, to give the user the effects of real marijuana. It's not real marijuana. It may look like it, but it's not. It's a chemical compound that has been applied to some type of herb substance so that it looks real, it looks organic, but in reality it's not. And I put GWH 018 at the bottom. That comes into play here in a minute when we talk about some of the state laws that have been passed to try to ban these substances. But each chemical compound has its own name. Usually it's a combination of letters plus a number, an acronym, like in this case JWH stands for John W. Huffman. He was a chemistry professor at Clemson in the 1990s who developed this, sort of is credited with the development of synthetic cannabinoids. And so when you see these articles in the paper, oftentimes they will throw out some of these chemical compound names, and that's where they come from. Now, as I said, Spice looks like marijuana, but it's not. In fact, it's often sold in head shops and record stores probably not the right word to use because that dates me, doesn't it? But it's sold in places that sell incense. And buyers are typically warned not to consume this substance, this incense that they're buying. But many times, of course, the sellers know that's exactly what they're going to do. As I said, it's not organic. It's made in a lab. It's applied to some type of herbal substance that looks organic, but it's really not a drug itself. It's the chemicals that are applied to it. And there are all kinds of names out there. Spice and K2 are the most popular, and so they sort of take on that generic name for the whole cadre of synthetic cannabinoids. But you can see some of them here. If you went on the internet and did a search, you'd find dozens upon dozens of different names. Now, the problem with synthetic marijuana is that, you know, as you go down to that very last bullet, there are really no rules among the makers of these substances. One person did a study of 100 different packets of K2 and Spice and found that there was no connection. There was no trend from one batch to the next. It's a very disturbing thing when you think about it. And people are using it. And sometimes these strains of or various products called K2 and Spice can be many, many times more potent than real THC. THC is the psychoactive ingredient in marijuana, and sometimes the potency of fake marijuana, in this case a particular chemical compound called HU210, is between 100 and 800 times more potent than real THC. And the effects go beyond, you know, just having a mellow experience and sort of phasing out of reality to enjoy, you know, what you think is marijuana. It can cause heart racing. It can cause hallucinations, seizures. People have even been known to do things that have caused death while under the influence of K2 and Spice. And we know that this is a problem across the country, not just because there are headlines all over the place, which there are. You can find them every day. We post them on our website in Drug Testing in the News. But also, the American Association of Poison Control Centers reports the calls that come into the centers around the country regarding the harmful effects of spice, and they have skyrocketed. Just 13 calls in 2009 to over 7,000, almost 7,000 calls in 2011. I don't have the final number for 2012, but there were 639 calls in January of 2012 alone. In the government's Monitoring the Future survey, which looks at drug use among young people, almost 11.5% of 12th graders admitted to using K2 or spice sometime in the last year. So these are really disturbing numbers and trends. Here's a little bit more for you on the industry itself. Drug courts have found a 15% positivity rate for synthetic cannabinoids. Probation officers and counselors around the country reporting an increase in cases involving synthetic cannabinoids. Fake marijuana. Okay, now, the federal government passed a law. President Obama signed it July 9, 2012, just last year, almost a year ago, to essentially put certain classes of synthetic cannabinoids and two substituted cathinones, those are the bath salts, okay, methadone and MTPV, into the controlled substances list, the Schedule 1 of the controlled substances. That's where you'll find marijuana, the real marijuana, and heroin and cocaine and other drugs like that. The problem is, well, before I get to the problem, let me go back to this slide and just point out that the problem with this, and the problem that you see with the various state laws that are being passed, is that once a certain chemical compound is banned, then the makers just tweak the chemical compound, and suddenly it's not on the list of banned substances anymore. So they're always trying, these manufacturers of fake pot are always trying to stay one step ahead of the law. Some states have gotten wise to that and have started passing laws that take in the whole genre of this drug. And we'll see how those laws go over the next year or so. But why would we be having a discussion about fake marijuana when there's such a problem with real marijuana? And part of it is because in the workplace, the use of fake marijuana is a growing problem. And employers are perhaps in some ways under the false notion that the drug tests that they're doing for marijuana, for real THC, can also detect synthetic cannabinoids like K2 and spice, and that's just not true. You have to test for those chemicals in order to be able to detect them. So people may be shying away from marijuana to use fake marijuana and actually getting away with it. And the other problem, of course, is that there are people out there, as difficult as this may be to believe, who think that because it's not real marijuana, it must not be harmful. And therefore they use it thinking it's a benign substance, and they're just sort of enjoying the high that they get from it. The truth of the matter is fake marijuana, synthetic cannabinoids, are as harmful and in some ways even more harmful than regular drugs, but they contribute to the trend in many ways. Another trend that is sort of part of this legal impairment concern that we have is medical marijuana. That is a trend throughout the country. And before I get into the states that have those laws, let me just get a couple of things straight. One, the Department of Justice issued guidelines for federal prosecutors back in October of 2009 indicating that it would not be a priority of the federal government to go after individuals who are, quote-unquote, lawful medical marijuana users or their caregivers. They made the point that they would not tolerate traffickers who are functioning outside of the law, but that they're not going to go after the users of these substances who are lawfully using the substances themselves. And that's a key point. That's a key point that we want to keep an eye on because some people hide behind that a little bit. The DEA kind of didn't really buy into that. They issued a statement in 2011 basically reiterating the fact that marijuana, even if it's legalized somewhere, is still listed as a Schedule I controlled substance under the Controlled Substances Act. And to get on that list, a drug has to, 1, have a high potential for abuse, 2, have no accepted medicinal value for treatment in the United States, and 3, there's evidence that there is a general lack of accepted safety for its use. I'm going to talk about that under medical supervision. I'm going to talk about that in more detail in a minute. But the DEA kind of went contrary to the position of the administration on that particular point. Now, these are the states that currently have medical marijuana laws. Take a look at this list. and see if your state or the states where you do business is on this list. The reason I point that out is yesterday I was on a call with an employer who was talking about the need for his policy, and that's what we do. We write drug testing policies. And he was talking about the fact that there were, quote-unquote, 4 states in the country with medical marijuana laws. Well, there are actually 19 states plus the District of Columbia that permit the use of marijuana for medicinal purposes. And it's a growing list. Now, I put the 3 in red. Those are the ones that have most recently passed their laws. And if we had time, I'd get into Maryland, which is really different than all the other states, but they passed a law this year. Nevada actually amended an existing law to establish legal dispensaries for marijuana, which they did not have before. And Oregon amended its existing medical marijuana law to add post-traumatic stress disorder to the list of illnesses and diseases that could justify a recommendation for the use of medical marijuana. Now, keep in mind when I say it that way that because marijuana is a Schedule I controlled substance under the federal law, a physician cannot actually prescribe the drug. A physician can only recommend it. In some states, like California, the law says they don't even have to write out the recommendation. They can just verbally recommend it to an individual. But it can't be prescribed. And for that reason, there's really no control over the dosages and the amount of the drug that you use to treat a certain type of illness. I've got a little bit more on that coming up in a second. This is the list of the states that looked at medical marijuana legislation in 2013. The ones in red have already died. For whatever reason, they're no longer active in that state. Maybe the legislative season ended, maybe it got voted down, etc. The ones in black are still active. Maryland and New Hampshire actually are still, Maryland's passed the amendments that I mentioned. New Hampshire actually is expecting to have a July signing of a bill that was passed in the state legislature. That'll be interesting because that will be the 20th state if, in fact, that happens. Wisconsin is still anticipating the introduction of legislation this year for medical marijuana. So in the states that are in black, the issue is still alive and well, and there's still a possibility that either the state would pass the law. Illinois has already passed the law in the legislature. They're waiting for the governor's signature. He had 60 days to sign it. Hasn't signed it yet. I just checked before we came on today just to make sure. But these are the states. Now, the interesting thing about this list, the states with medical marijuana, and this list, the states that are looking at medical marijuana, as we get into the legalized pot states like Colorado and Washington, you're going to find out something very interesting that connects that initiative with these 2 lists. Okay, but before we get to that, the intent of these laws is to decriminalize the use of marijuana for individuals with serious debilitating medical conditions. You'll find that phrase in many state laws with medical marijuana, even though they're all different from one state to the next. You'll find some common verbiage from one state to the next as well. In California, quote, it says, quote, unquote, remove state-level criminal penalties on the use, possession, and cultivation of marijuana by patients who possess, and remember I mentioned this, a written or oral recommendation from their physician that he or she would benefit from medical marijuana. And it can be all kinds of things. As you can see at the bottom there, it could be something as serious as cancer or multiple sclerosis, or most of these laws actually contain a catchphrase called, or something like the one in California, other chronic or persistent medical symptoms. Well, that could be a lot of things, right? I mean, that could be the stress that you feel every day on your drive into work, or that could be your husband or your wife nagging you to take out the trash or to mow the lawn or whatever. Well, I'll get to it, but I got to smoke a joint first because I'm feeling pretty stressed out, and my doctor recommended that I do that. I've just called him orally. He recommended it over the phone to me. I mean, it's pretty loose. And a lot of states have similar type of language that remove state-level criminal penalties that may mitigate the debilitating symptoms of an illness, et cetera, as you see in Alaska, you see it in Oregon, Colorado, might benefit, et cetera. It's intentionally meant to be somewhat loose. Not very many, or about half of the states, I should say, not all of them, have some type of workplace phrasing. Some of it's protective of employers, some of it's sort of protective of employers, and some of it's really more protective of the drug user. You can see this is the language from Massachusetts. Here's Connecticut. It went a little bit further. It seems to be protecting the rights of employers, but then you see that by the law, an employer really can't do anything to penalize a medical marijuana user on the payroll. Can't fire them, can't intimidate them, of course, or penalize them in any way. You see this throughout the country. Now, there was a case in Michigan, Casillas versus Walmart, in which a registered medical marijuana user was fired by Walmart after testing positive. He challenged it, and the court actually sided with Walmart because it basically said that there was nothing written in the law that applied to the private sector. And so there was nothing in there that prevented a private sector employer from firing somebody for testing positive, even though they, quote unquote, used it legally. And so now you're starting to see the language like we see here in Connecticut, where it prohibits employers from being able to terminate somebody who is a medical marijuana user. Okay? Now, the federal government has tried a few things. There was a challenge to the positioning of marijuana as a Schedule I drug. The U.S. Court of Appeals in Washington, D.C., District of Columbia, actually ruled in favor of the DEA on this issue, and so that sort of killed it for this year, but it may continue. You're going to get these slides. Actually, you'll have access to the slides, and you can go and use this link here if you'd like to read the whole thing. It's a lot of information, but I didn't actually want to put it all in a slide. If you want to learn more, though, about these bills, let me tell you where you can find all the information you want out there at these websites: theweedblog.com, forumgrasscity.com, AmericansForSafeAccess.com, StopTheDrugWar.com. These are the sources of information that are out there on the internet that are fighting the good fight if you're in favor of legalizing marijuana. There's not a lot of information out there countering these arguments. So when you go onto one of these websites and you read about this U.S. Circuit Court of Appeals decision, you get a very, very one-sided view of the decision. Okay? I just want to point out, I thought this was fascinating. The District of Columbia actually passed a medical marijuana law. It's taken a couple of years for it to really roll out, but now the first legal dispensary has opened, and it's just a few blocks down the street from the White House and from the Office of Drug Control Policy, which is across the street from the White House. Not too far from the FBI office, the Drug Enforcement Administration office, or the U.S. Capitol. So it's illegal by federal law. It's a Schedule I controlled substance. And in the nation's capital, there are legal dispensaries that are opening up within walking distance. It's a kind of a hefty walk there. I lived in Washington, D.C. at one time. But you could get there very easily from the FBI building, the DEA offices, even from the White House. So just a kind of an interesting note. I'm going to skip the California thing. If there are any folks here on the line from California, I used to live in California. I was born there. I don't want to be disrespectful, but of all the states that have medical marijuana laws, it seems to be the most chaotic and unregulated and out of control in the state of California. There's some information there for you on that. Now, as we make our way to policy issues, let me just touch on legal pot. We know that Colorado passed a law in 2012 legalizing marijuana use. There are some provisions that apply, 1 ounce up to 1 ounce. You have to be 21 or older, things of that nature. There is a provision in the Colorado law on the workplace. Nothing in this section is intended to require an employer to permit or accommodate the use, consumption, possession, transfer, display, transportation, sale, or growing of marijuana in the workplace, or to affect the ability of employers to have policies restricting the use of marijuana by employees. Nothing in there on drug testing, nothing in there on penalties, but we'll likely see that kind of language coming out in future legalized marijuana legislation in the future. Washington also passed a law. The two are somewhat similar. There are some significant differences. For example, in the Washington law that was passed last year, there is no employment provision as there is in Colorado. However, in the Washington law, there is a DUI cutoff level for THC of 5 nanograms. There wasn't initially in the Colorado law that was passed, but there have been, those things are being considered and passing recommendations that were made, and the governor is actually approving these various recommendations, including a DUI level for THC. The federal response, you can see this was an interview with Barbara Walters right around Christmas time, where the president said, quote, "We've got bigger fish to fry." Basically, if the voters want this in their states, then we're not going to really go after that, even though it's against federal law. So that kind of doesn't make sense in many respects, right? You can't pick and choose which laws you're going to enforce just because the voters in a particular state created a law that contradicts or goes against federal law. But in this case, that's what the administration has chosen to do. The U.S. Department of Transportation, which of course is the major source of a lot of drug testing that goes on in our country, said, hold on, we don't recognize these laws. The state initiatives will have no bearing on the DOT-regulated drug testing programs. Medical review officers will not verify a drug test as negative based on recreational marijuana as the excuse for that. And they were very, very clear about it. They sent out this statement publicly, and it's been distributed all around the country to drug testing providers as well as employers. Every employer should know this is the position of DOT. If you fall under the DOT regulations, you are still expected to test for marijuana and to hold people accountable for testing for marijuana. Now, here's the list of states that have introduced recreational marijuana laws, or bills, I should say, in 2013. So far this year, no state has actually followed Colorado and Washington and passed a new law. But these are the states that looked at legislation. The ones in red, again, are dead for this year or for this legislative session. The ones in black, still active right now as we speak. Here's the rest of the list. Vermont, red, everybody else, black. So there's still some movement out there. There are still some battlegrounds out there. But most of these states, if not all of them, well, not all of them, but most of these states actually have medical marijuana laws. Not Pennsylvania and a few others, Ohio, but that tends to be where the pro-marijuana movement softens the beach, by getting medical marijuana laws passed. We won't go through these next couple of slides, but these are the amendments that Colorado is now adding to its recreational marijuana law to take care of a lot of loose ends, including the taxing. At what rate will they tax? At what intervals will they tax? Will the manufacturer be taxed? Will the wholesaler be taxed? Will the retailer be taxed? Will the consumer be taxed? And of course, the answer to all of that is yes. And at some point, you have to ask yourself, well, when do they price themselves out of the market? When they're competing against illegal marijuana traffickers who are selling it for a lot less because, well, let's face it, they don't charge taxes, so they never have. It is important to point out that in Colorado, there was a significant piece of case law that came out in favor of the employer for an individual who tested positive for marijuana. Now, he tested positive a couple of years before the law was passed. But even in light of the passing of the law, the court ruled in favor of Dish Network by essentially, and this was the argument that Dish made, that marijuana is still illegal under federal law. And as an employer, we are obligated to follow federal law. And the court sided with the employer and that argument. So that's pretty significant. A couple of major cases have gone against the pro-marijuana people. The Walmart case in Michigan and now the Dish Network case in Colorado. And that is actually being addressed in the language of these bills that are being introduced around the country, where the pro-marijuana people are actually getting language written into these bills that would protect against these types of lawsuits, the Dish Network and the Walmart cases. Okay, just as a kind of a humorous side note, the state of Idaho kind of took things way, way, way to the other end, where they actually passed a resolution in which both the House and the Senate proclaimed the opposition to the legalization of marijuana in states around them, like Colorado and Washington, right? Drug legalization laws in neighboring states have already adversely impacted Idaho through cultural acceptance of drug use that reduces the perception of harm among children and increases drug use. And so Idaho really couldn't do anything about it, but they did pass that resolution to voice their opinion on the issue. Now, if you're in the business or you're an employer, it's important to know that employers still have the right to test employees for marijuana. They still have the right to hold individuals responsible for their use of marijuana in the workplace or being at work under the influence of marijuana. in a post-accident reasonable suspicion situation, you still have the right to conduct a test and include marijuana in that panel. But a lot depends on having all of this written into your policy, that the prohibited behaviors, the drug testing section, and the consequence sections specifically take on marijuana, especially in states where you have medical marijuana laws and recreational marijuana laws. It may be something if you're a multi-state employer or you're working with a company with operations in all 50 states where you're going to want it written into the regular policy anyways. But you want to make sure that you address the issue. There are two schools of thought when it comes to writing a policy. Put as little in as possible or put in everything. I go in the latter category. I like to make sure we've covered all the bases. And so for any of you who are thinking about whether or not you really have the right to test for marijuana and how your policy should address the issue, my advice is to take it head on. Make sure it's in the policy in all the appropriate places, and that your employees understand and your job applicants understand that you're going to test for, among other drugs, marijuana. And ensure that your policy is compliant with the state laws, but keep in mind what happened in Michigan, what happened in Colorado with Dish and with Walmart, and know that at least in the most recent major cases, the law has sided with the employer on this very important issue. Okay? Now, I want to say a few words before I turn it over to Robin on marijuana. One of the major misconceptions about marijuana, and I think this is really starting to go away, is that marijuana can't detect oral fluid. That oral fluid cannot be tested to detect marijuana. Well, that's not true. The opposite is actually the case, but there's more to it than that. But let me make this point, that the Substance Abuse and Mental Health Services Administration, SAMHSA, which governs and regulates drug testing at the federal level, which affects many private sector employers, is in the process now of developing regulations for lab-based oral fluid testing. And so that's happening because the government has, perhaps even stubbornly, resisted the movement toward this technology, but they have finally had to admit that lab-based oral fluid testing is there. The science is solid. It can detect drugs, and especially when we're talking about lab-based, okay, there's a big difference between lab-based and instant oral fluid testing, the technology, the science, and many of the major issues. But when it comes to lab-based oral fluid testing, generally speaking, there is no difference in the accuracy of lab-based oral fluid testing and traditional lab-based urine testing. Now, typically marijuana is detectable through oral fluid within about an hour of use, if not immediately. The truth of the matter is it mimics blood. So because the body is constantly producing saliva, oral fluid, which mimics the blood, what's in the blood system, it's able to detect drug use almost immediately after the individual ingested the drugs. And so you're able to actually use oral fluid as a great indicator of recent use. Somebody who comes back from a lunch break, smelling of marijuana, acting like they're high on marijuana, and in a reasonable suspicion scenario, that individual is probably going to test positive in an oral fluid test when they might test negative with urine and certainly would with a hair test, right? Because that's, as you're going to see, that has a much longer delay before you can detect the drug. The cutoff levels used are a big, big factor, okay, in the detection of marijuana. You have to know the cutoff levels of the product or the service that you're using. I'm going to show you a chart that kind of illustrates that in a minute. As I mentioned, there's a big difference between lab-based and point-of-collection or POCT oral fluid testing. Okay, but that window of detection is critical, okay? First, let me talk about cutoff levels. That red dotted line right there that you're seeing, that's 50 nanograms, okay? So everything to the right of it is higher than 50 nanograms. And you can see that those blue bars, which represent positive drug tests, they're fairly low, above 50 nanograms. But below 50 nanograms, you see those bars starting to shoot up, and especially down at 5, 10, 15 nanograms, that's where you really see the vast majority. In fact, 80% of all THC positives are below 50 nanograms, and the vast majority of them are below 25 and 20 nanograms. That's important. So when you're looking at oral fluid, you've got to make sure you ask, what cutoff level are we testing for with THC? Now, here's the window of detection. You can see that the blue line and the red line, which represent oral fluid and blood, they start immediately after use, within minutes after use, okay? Whereas urine is going to be about an hour after use. You can see that urine goes out farther. The window of detection is a little bit longer, but it's going to miss some of the people on the left side of the frame, okay? So when you compare the two, oral fluid with its immediate ability to detect drug use and urine with its slightly longer window of detection, the positivity rates are going to kind of come out about the same. In fact, I've got a chart that shows this, 4.1% overall positivity rate with the Intercept oral fluid lab-based test versus 4.4 for urine from a study that was done by Quest Diagnostics some time ago. If you go down to the THC line, though, you'll see that actually the positivity rate for THC was higher with oral fluid testing in the lab versus urine testing. That really goes contrary to the, to the opinion and the misconception that's out there that you're not going to be able to detect THC. Okay? Now, I'm about to turn it over to Robin. There are a lot of advantages to oral fluid testing, and she's actually going to talk about those and how they've applied in real-life situations. But when you're looking at what drug testing technology you want to use or which is best for this person or this company or that company, I think you've got to include lab-based oral fluid testing in your research and in the debate now, not just because the federal government's about to approve it and regulations are on the verge of coming out, but the technology is out there, and some of the advantages like the ability to collect a sample with an observed collection every time, the almost impossibility that exists in trying to cheat on an oral fluid test versus a urine test, et cetera. These are things that Robin will talk about. They really point somebody in the direction of oral fluid testing and the advantages of oral fluid testing. The cost factor, the streamlining of the process are all making it so that a lot of people now are looking at oral fluid testing as a viable alternative. And that's something that's come out in the last couple of years in our annual survey of the drug testing industry. So with that in mind, let me turn it over to Robin, who is really out there in the trenches working with companies that are doing drug testing and that have looked at different methods of drug testing. She'll have probably a more accurate and real life view of that than I can present. So Robin, let me turn the time over to you.
Okay, thank you, Bill, and good afternoon, everyone. We certainly appreciate the opportunity to speak and all that OraSure technology does for us. Their support, it's just great. And I want to send a special thanks out to Sandy Burke, who is our rep, who is just always there for me, for our clients, and we appreciate that so very much. I am going to talk about the advantages of oral fluid testing. And the first thing is just the flexibility that oral fluid brings to the table today, that it can be collected anytime, anywhere, of course by someone that is trained. Just overcome so many issues that we've had to deal with over the years for collection sites and then other things too. It's really revolutionized the drug testing industry. We started using oral fluid testing, I guess it was about 12 years ago. We offered it to our current clients, and then we took it out and offered it to new clients, to prospective clients. And it was just amazing to us how many of those clients, once they learned about oral fluid testing, were just ready to switch. And now it seems like, to be quite honest, I rarely sell any other kind of testing just because once the advantages are realized. People were a little apprehensive at first, and I think that was just a matter of educating them. When they realized the benefits that Intercept provided, number one, it's a certified lab test. It's FDA cleared. It is by all means legally defensible. And it's just really a better way to detect recent use. It pretty much sells itself. Some of the things that I heard when I started talking about it, and even now to some degree, it's like, you want us to collect an oral saliva test? Well, we don't want to do that. But once they realized they did not have to stick the swab in the donor's mouth, that the donor pretty much self-collected, they put the swab in their own mouth, it stayed in there for a certain time period. Not only were they relieved, but then they, had the mindset, yeah, we can do that. So then that was kind of resolved, which was really great, because I had always realized that Intercept and oral testing was just such a great tool to use. And then for the collection process, OraSure provides a wonderful online collection training for the collector. And, of course, you know, it's great for the employer because it prints out a certificate to document the training. So that's a great thing for them just to keep in their files and all. When I go out and talk to employers who have administered different kinds of drug testing, it became evident that they really embraced the oral testing a whole lot more than some of the other tools that they had used, and were excited about using Intercept in the oral testing way. They could clearly see the advantages of it, and they were on board and ready to switch, so that was great. So let's look at some of those advantages. One of their first clients that made the switch to oral saliva was a large manufacturing company that employed both males and females. They had locations across the country, and they were really tired of hearing about their employees that they had heard through the grapevine, of course, that smoked marijuana but still managed to beat their drug test. And then, not to mention, they were a 24/7 operation, which meant they had all the challenges of the odd shift, and it was just difficult to test those folks. It was expensive to bring someone in to set up the bathroom. You know, it was invasive to line people up to have the test done. So a lot of hurdles. Of course, that's not to mention the shy bladder that would creep up every once in a while, which meant that the collectors would have to wait for hours. So the oral test really overcame all of those concerns, and obviously it just saved them a lot of money and saved a lot of time because they could, you know, not have to practically shut a shift down to test the people that needed to be tested. They could do it, you know, anytime that suited them. So that was really great for them. The employees liked it. They liked it because it was less invasive for them. When you've got you know, female and male genders in a workplace, you know, there are issues there sometimes, and this really just overcame all of that too. And the employer liked it because there wasn't any more yuck factor. You know, if they had to do the collection, they certainly didn't mind doing the oral saliva collection. And they liked it because it was virtually impossible to beat, which was one of their main concerns for reaching out and looking at this tool to start with. Intercept just made it really easy for them to test, you know, all of their shifts, and to help them to really have what they wanted, which was a drug-free workplace, and to keep their employees safe, which was important to them, of course. As we're out there selling drug testing and all, we have a lot of different kinds of clients. We do a lot of retirement homes, nursing homes, and have seen most of them switch to oral fluid tests. And there again, when I sign them up, once they hear the advantages, they almost always choose the oral fluid test. But they also struggled with the 24-hour operations, and you can imagine, you know, they serve a very vulnerable population. So it's so important for them to be able to test 24/7 and do a good job of that. So Intercept overcame the challenges there, but they also liked Intercept because Intercept offers an expanded panel, so they weren't tied to doing a limited amount. They had other options to do that. The nursing staff, they loved it because oftentimes they had been the ones in the clinic area that had been doing the collections and would much prefer to do an oral saliva collection rather than a urine test. So it was a situation, you know, in both of these cases where the employers loved it, the employees appreciated it, and the collectors, of course, loved it too. So it just kind of really overcame so many different things. It always surprises me when I'm out there talking to folks how many employers really don't grasp the fact that people who use drugs sometimes will succeed, but will certainly try to beat the drug test. It's not surprising that we hear about situations where, you know, the they're ready to make the hire, they've made the offer, they're going to do the drug test, the pre-employment drug test, and they pull out the oral saliva test because they're going to accomplish that right then and there. You know, they're not going to hand them paper and send them somewhere, and they've got several hours to do the drug test. And the donor will just mysteriously have a personal emergency of some kind and have to leave or remember a doctor appointment or have to go to the bathroom and never came back. So they don't have to deal with that. They know the test was done. We've had situations where our clients have called us looking for drug tests, and when we start to do the research, we realize that, you know, the candidate never even showed up for the drug test, and that was because you know, they came prepared to beat a urine test, and when faced with the oral test, realized that just maybe what they had wasn't going to work for them. Urine tests are susceptible to, you know, drug test cheating. You know, simply superhydrating your system, drinking a lot of water before the drug test for a urine test can cause a dilute specimen or low creatinine result. And that means for the employer, oftentimes they want to send the person back, do another collection. It might still come back negative dilute, and of course that, you know, a DOT is a negative result. But they never really know, was that an attempt to beat the drug test or not? So they're kind of left hanging there with that. And if you're going to spend money for a drug test, you certainly want to be clear that you got a good, solid result there, don't you? Oral drug testing is very difficult to beat. The donor knows that just simply postponing an oral fluid drug testing, you know, I can't come in today, you know, I've got to do this, making all the excuses to buy time is another way that they can kind of put that off and cheat the drug test. But the collection for oral fluid takes place in the presence of the donor and the administrator of the test. So, you know, the typical cheating methods that are used, switching samples, and I started out being a collector in a lab, so I ran into some of those things, so I know it happens. But switching samples, adding something to the sample, you know, all of those things are avoided because it is, you know, really virtually impossible to pull that off with an oral fluid test. The notes here speak of, you know, doing a search on the Internet and finding thousands of hits. But yesterday, I typed in beat drug test using Google, and I have to tell you, I found over 59 million hits in 0.21 seconds, which is just pretty amazing because I know years ago we were all amazed that it was 1 million hits in a matter of seconds. So what we need to remember through all of this is that the drug users are out there. They also know how to get on the Internet. They hear the things. Oftentimes they know what to do. The labs certainly do their best to keep that from happening. But it's a real problem out there, and I think that Intercept really does a great job of helping us to have a good, solid drug test with the results clear, and that's what the employers are looking for. So at this time, I'm going to turn it back over to Bill now and let him wrap it up and finish up with their questions and all. Thank you.
Well, thank you, Robin. And there have been some great questions submitted, so I hope the people, we've got a pretty good sustain rate of people staying on the line through the end of this webinar. So there have been some great questions submitted. Let me throw one out, Robin, and maybe you can take a first stab at it. A question was asked, will an oral fluid test result hold up in court as evidence of a positive result? Have you had some experiences with that yet of the legal process supporting a lab-based oral fluid test result?
We have not personally had that challenge. For our clients and those that use oral, once I explain to them that it is lab-based, there is an initial test, there is a confirmation test, and all of their preliminary positive and positive results go through our MRO, then I think that calms their fears of it not being, not holding up in court. But personally, we have not. I know from talking to Sandy, our rep, and a few of the challenges that have been out there, that it does hold up in court. And you may, have some thoughts on that, I'm sure, Bill, yourself on that one.
Well, I think you hit it right on the nail there. One, I think it helps that it's lab-based testing, because then you've got, you can make the connection to the years and years of legal decisions related to lab-based urine testing. But beyond that, if you're using an FDA-cleared device, you're using a lab-based result, and you're complying with the state laws that apply to you. Robin mentioned having a medical review officer. I would add to that confirming an initial screen positive, a non-negative. If you're doing all of the right things to make sure that the integrity of your program is in place, then when you're talking about lab-based oral fluid testing with lab-based urine testing, as far as the legal system's concerned, as long as you're complying with the state laws that apply to you, the science is there. From a scientific standpoint, you're on solid ground with lab-based oral fluid testing. Again, as long as you're using an FDA-cleared device, I think that's very important. With FDA-cleared testing system in the laboratory and you're complying with the state laws that apply to you, I think, there's really not a difference whether it's oral fluid or urine. So that's a good question. Here's another one, and I'm not sure, maybe, Robin, you can help me figure this one out. There might have been sort of a misunderstanding in something I said or we said, but the question was phrased this way: how often do you have to test given the shorter window of detection for THC? I'm not sure exactly where that's going, but it kind of sounds like maybe there was a misunderstanding that because it's a shorter window of detection, you have to do a lot more tests, but that's really not the case, is it?
No, that's certainly not our experience. We've always said that with marijuana and Intercept, it is more of a current impairment, and I always use the term chronic user. So I think it does, and the science certainly supports this, it does a better job of detecting what's going on in your workplace. Maybe not looking at what they did recreational, a week ago, but what they're doing during your work time. And once I explain that to, my prospects and clients, most of them, that's exactly what we're looking for. We want to know that when we send a serviceman out into someone's home, that he's not impaired in some way, that he's clear and he's doing a good job. And you always have, and Bill, this is your department, but you always have, reasonable suspicion in your work, in your policy, reserving the right to do that. And so if you start to hear things or see things that you can document to make you think that, then, I would certainly do that. But we don't have clients who test more often because they're using Intercept.
Excellent point. Here's another one that came up. I'll take a first stab at it, Robin, but feel free to jump in. The question was asked, are we then saying that because oral fluid testing has that ability to detect drug use almost immediately after it occurs, that an oral fluid test is an impairment test? And I think in part the answer to that is still that, there's a lot of case law from years ago where the courts have concluded that a drug test doesn't actually prove impairment. But depending on how your policy is worded, you don't really care about impairment. Of course, you care about employees being impaired on the job, but from a drug test result standpoint, you're not trying to prove whether or not somebody was impaired. You want to just prove whether or not they had drugs in their system in violation of your company policy. So you can define a term like under the influence as, among other things, testing positive. And you're staying away from the term impairment. However, because it has the ability to detect drug use almost immediately after the usage occurred in a reasonable suspicion or post-accident testing scenario, it would be very, very challenging for that individual to claim that they used the drug, 3-4 days ago, when in fact they just tested positive with an oral fluid test that has that window of detection of, within minutes after use up to 24, 48 hours. It's really very conclusive that if they test positive with an oral fluid test, they've got the drug in their system at the time of the accident, and your policy considers that a violation of company policy. How would you add to that, Robin?
Well, I absolutely agree with that. And I think we need to go back to the slide where you were giving the overall positive rate looking at urine versus oral. And even though it may be a shorter window of detection, you still have a higher percentage rate of positives using Intercept. And another thing to think about there, that's not even counting all the people who, and I think I mentioned this to you before, Bill, who beat the urine drug screen, who aren't even on there.
Oh, yeah.
So I still think, in spite of the fact that the window is a little more narrow and kind of mimics the blood more, that you still overall do a better job for all those reasons that we've been talking about.
Excellent point. Now, you talked about the panel of drugs during your part of it, Robin. What drugs besides THC do your clients typically test for with oral fluids?
Well, I guess the standard is marijuana, cocaine, methamphetamines, amphetamines, THC, PCP, but oftentimes we will add benzodiazepines, barbiturates, and methadone. And a lot of times that's when it's in kind of a medical arena or when the company just has some concerns in that direction. So that expands the panels for Intercept beyond just kind of the standard, I guess, 5-panel is what we used to call it.
Okay. I think that's interesting because in all the years I've been in the industry, a lot of the smartest people, in our business, smarter than me, have always been making the argument that we're not always testing for the right drugs. And by that they mean we're not always testing for the drugs that are being abused. If you know that you're going to be tested for, say, that SAMHSA-5 that you mentioned, the 5 typical drugs, marijuana, cocaine, opiates, amphetamine, and PCP, well, maybe you'd then just become a benzodiazepine user or barbiturates or one of the drugs that's outside the panel. So, to the extent possible, you want to look for a wider panel of drugs to test for, but I want to underscore the importance of making sure that you're not only using an FDA-cleared collection device for your oral fluid testing, but you're also testing for assays that are FDA-cleared as well. And so that's an important question to ask your provider, to make sure that the drugs you're testing for are actually, that process is actually FDA-cleared as well. Somebody just asked this question. I think this is a great question because, we've been promoting some of the benefits of lab-based oral fluid testing for reasonable suspicion and post-accident. And I do that because there's a particular connection there. But that's not to suggest that it's not a valid testing method for pre-employment or for random, follow-up testing, return-to-duty testing, etc. It can be used for any testing scenario. The window of detection with hair testing, for example, if I went back a slide, you can see that it goes out the farthest. It's typically about 90 days. But it doesn't start for about a week after drug use. Now, if we're talking about a chronic drug user who's always smoking pot, let's say, then that lag time of about 7 to 10 days is not a big issue, okay, because they're always using it, so it's going to be detectable in their hair. But if this is an occasional user, then it may not show up in a hair sample. But if you want that long or wider window of detection up to 90 days, then hair testing is really your only option. But that's not to suggest that urine, of course, and oral fluid are not, great testing methods for pre-employment screening as well as random testing. And I'm assuming as well, Robin, that you've got clients that use it for all kinds of situations.
Absolutely. Typically, our clients who use Intercept use it in every situation. They use it for pre-employment, random, post-accident, return to duty, reasonable suspicion, all of the pieces of their drug testing program. And I think it's important, too, that it provides consistency with what they're doing. When you look at the fact that urine drug tests can be beaten, and Intercept is virtually impossible to beat, I think it absolutely makes sense for pre-employment. You don't want to spend money in your drug testing program for a tool that's just going to be beaten, and you're not going to accomplish, you know, the full goal of what your drug testing program is meant to do, and that's to not hire, you know, those potential drug users and problems and accidents and all the things that kind of follow them.
Good answer there. We're almost out of time. I want to just cover one last thing, which is somebody asked the golden question. When's the federal government going to approve oral fluid and put out those final regulations? And I think I can speak for Robin and myself both when we say if we knew the answer to that question, we could make a lot of money. But there's really no way to predict. We're looking to see some version of the regulations this year, hopefully for public comment, maybe towards the end of the year, the beginning of next year. It's still going to be a while. Now, the U.S. Department of Transportation has signaled that they are going to approve these regulations once SAMHSA comes out, but even that process is going to take time beyond the SAMHSA process, so it's going to be a little while. Is that basically how you would answer it, Robin?
Absolutely, yeah.
I think the positive, though, is that because the federal government's in the process of approving lab-based oral fluid testing, we're seeing a significant increase in interest for this testing technology. And I'm somebody who is a fan of all kinds of drug testing. I frustrate people all the time because they'll ask me, Bill, what is the best drug testing method? And my response is it's not really a question of which is the best one. It's which one's best for you and your circumstances. I've been a proponent of lab-based oral fluid testing for many, many years. And the technology, the science, everything behind it now is really drawing a lot of attention. So this is probably the beginning of, I think, a significant shift in market share among the different testing technologies. So with that, I'll turn it back over to Jessica to conclude our webinar.
On behalf of OraSure Technologies, we hope that you have found today's webinar presentation informative and helpful. This presentation was recorded, and you will receive instructions informing you how to access the recording. Today's presentation is approved for 1 credit hour of continuing education for CSAPAs from SAPAC. Please use this unique identifier 0180-1306-current, CURR ENT in association to that credit. Again, the identifier is 0180-1306-current, CURRENT. Thank you for your attendance today. This concludes today's webinar.